It's my honor and pleasure to be here, and thank you for Cochin Institute of International Arbitration to invite all of us. And I'm sure that this is going to be a great beginning of our relationship with the Southern India, where we need to bring arbitration in the same level as we have in other parts of the country. With that, Dr. Bhasin and the dignitaries on dais, ladies and gentlemen, I'm going to talk about the critical analysis of the Arbitration Act. We heard Mr. Ratan Singh with regard to the need for infrastructure. And one of the infrastructure which we need is the conducive law for making the arbitration as the preferred mode of dispute resolution. And whenever we are drafting an arbitration clause, we always think about what should be the seat. And the seat, the question comes is there an arbitration-friendly jurisdiction? Now, what is arbitration-friendly jurisdiction? Which is the law of that particular country or the seat is promoting arbitration, is pro-arbitration, and not, the courts are not taking away the jurisdiction from the arbitrators and try to conventionally exercise the jurisdiction which the judges have been conferred by the statute. And that is where the law becomes very important. And the Arbitration Act in each of the jurisdiction is based on the ancestral model law. But the way Indian Arbitration Act performed, because of the judicial interpretation, that has led to a lot of confusion, and that's why we had to amend it. And the amendments were quite drastic. I was part of the committee, and it was vice versa with Dr. Bhasin. I was in fact privileged to be to working under him and his guidance, as he said in the morning. And it went into a quite detailed discussion, and we amended the law. Now we have the amended law, but what happened in the process is that there were a lot of suggestions which were given by Law Commission, which has not culminated into the law. And as usually what happens is the law came by way of an ordinance, and then it was formulated, promulgated by the parliament. So ultimately the real underlying theme of the amendments was to promote institutional arbitrations. And how, I'll give you some examples. One was the major amendment which was suggested is to recognize the arbitral institutions and encourage the high courts or the judicial appointments which are happening through the Section 11 process to promote institutional arbitration. That was the underlying theme, and several suggestions were given. One was recognizing emergency arbitrator as the arbitral tribunal itself. So definition of tribunal would include the emergency arbitrator. And what is emergency arbitrator? You don't, if you need an interim relief immediately, you don't have the arbitral tribunal. The only option left is to go to the court and get the interim relief from the court. What happens in process is that you file all your pleadings before the court, and you know exactly, you get an ex parte order, or even after service, you involve the court. The process, the way it should happen and the way it is happening in other jurisdictions is that the involvement of court is minimal. Starting from the interim relief, from appointment of the arbitrators, and also with regard to any challenge to the arbitrator, everything is done by the institutions. And why? Because the law is supporting that process. So when you have an institutional rules selected as part of your contract, and you have robust institutions who are able to have the processes in place which can definitely make the arbitration faster. For example, if you have an emergency arbitrator, within 24 hours the arbitrator would be appointed only for deciding the interim application, and the award comes or the order comes in 3 to 4 days, which is very efficient when the institutions are there to support everything. And we have been part of those processes where it has been complied with the parties. Now what happens in India is that because that entire concept of emergency arbitrator which exists in Singapore, Hong Kong, is not incorporated into the law, we have a doubt whether that order will be enforced or not. and we don't have institutions who are providing that kind of services. So it's a catch-22 situation where we don't have the institution, the law is not recognizing it, and therefore that needs to be fixed as early as possible. We need to bring in the concept of emergency arbitrator and appointment of arbitrators by the institutions. And what infrastructure we need is that rather than having multiple rules, if we can have one particular set of rules, because ultimately the purpose is the same. If you have different rules to govern the institution arbitration in India, and what we are comparing ourselves is not countries. Singapore is a nation state, and we are talking about London. We have never spoken about UK. In India, given the size and the kind of the variety of courts we have, we need to have uniformity. That's something is very important for promoting institutional arbitration in India. We don't have uniformity, so we are not able to sell. You can call it by any name, but what is the difficulty in having the uniform rules? These uniform rules will definitely help to promote institutional arbitrations in India. Most of the time what happens is that the court appointed arbitrators, and now we have this Schedule 5 and Schedule 7, where the court appointed arbitrators are there, where the lawyers are either advising some of the clients or the judges who are appointed mostly, which is again a criticism. If you go to institutions for appointment, and either the parties can nominate their arbitrator in the three-member tribunal and the chairperson is decided by the institution, or in the sole arbitrator. I've been appointed by ICC in a couple of arbitrations, and there is no problem at all, because the disclosure form which the ICC has formulated is so detailed that even before the appointment, everything will be disclosed in that form. So even as a potential arbitrator, you can be, your CV is attached to that, you're all past this thing, and in fact 2 years calendar or 1 year calendar is also asked by them, and they say that you will make yourself available for this particular arbitration. So that kind of minute observation is maintained by this institution, and we have much more to learn from them. As Mr. Singh said, we have to collaborate with them and understand. It's not difficult, because all of us are party to all these arbitrations which are conducted by other institutions. And they have the rules, they have the infrastructure, and we cannot divide the infrastructure with the rules. So that's where we have to provide everything there. And especially if you have a challenge process, do you have LCIA has a court, even Singapore International Arbitration has the board of this thing, and ICC has the ICC court. They decide the challenges. The rule itself are sufficient enough or self-contained to kind of resolve all these initial hiccups. So the main focus is resolving the dispute, not getting into the litigation relating to arbitration. As many people ask us, what do you specialize in? So we say we specialize in litigation relating to arbitration. So that is where the difference is, that we have to specialize in arbitration rather than litigation, which is arising out of the arbitration. And that is what is the problem with the existing law. Even after the amendment, there are a lot of improvements which can be done by recognizing the institutional arbitration. They also need to see that the appointment process or the reference to the arbitration. Now we have Section 8 and 45. Section 8 says that the prima facie existence of an arbitration. This is a new concept which has been added by way of an amendment. Now what is the question may arise is that what is this prima facie assessment by the tribunal, and whether it is binding or not. So that may raise the questions with regard to the applicability of the law and the interpretation, further interpretation of law as far as institutional arbitrations are concerned. Also, the big question is that can two parties have seat outside India, and that's still not settled by the Supreme Court. They've kept that question open, and that is one reason that two parties are also going out of India, because they don't have this institutional arbitration in India. So Indian parties are going out of India and arbitrating. Why forget about we are getting foreign parties to India. So we have a lot to achieve as far as the arbitration institutionalization is concerned. And the other aspect is also promote the bar of arbitrations by training, and training is something which can be there as a part of this process, where we can definitely have the higher level of arbitration bar, which can then cater to the arbitrations being conducted in India. So just to conclude, the law which is there at present is the amendments have brought us to much ahead of the requirement of the arbitrations in India. But if we kind of change it little bit, one is the change of attitude and the other is change of mindset. By the judiciary and the users, it can really create a lot of changes in India, and we can bring about the desired changes with regard to the law of arbitration in India. Thank you.